I'm Daniel McCracken, Head of Private Client at MKB Law. I'm joined by Kelly Shaw, Head of our family team. We're here to talk about the Supreme Court's latest judgment in Standish and Standish, which is obviously a big family judgment. It's been long awaited. It's a lot of talk about it at the moment. So what's it about?
Well, Standish and Standish involves two very wealthy people, but the principles of it are really helpful for all matrimonial cases because it looks at how property is dealt with by the courts, what's matrimonial and what's non-matrimonial property, and when non-matrimonial property becomes matrimonial property. But in this case, the parties were married and there was a dispute because the husband transferred approximately £80 million to the wife in 2017. And the facts of the case were that he did this transfer with the intention that the wife would set up a trust in the names of the children, and the purpose of it was for tax planning. Because the monies then were in the name of the wife, she claimed that title made the money hers and felt that the money should be therefore shared under matrimonial law, which would mean she would get 50% of it. When it went to trial, the judge held that part of the monies had become matrimonial property, and therefore the judge made a 60-40 split to the wife, which gave her 45 million at that time, and the husband had then appealed that to the Court of Appeal.
Okay, so from my reading of it, the reason for it was for tax planning, was really why the husband had transferred this 80 million into the wife's name. And just for those listening, the part of the reason for that, as I understand it, is that the husband was from the UK, but the wife was from Australia. He had lived in Australia for a long time and had built up a lot of wealth in Australia, and had probably adopted what's called a domicile of choice in Australia, which is where he is deemed to be, he set his roots down in Australia, and for UK inheritance tax purposes, only his UK assets would have been taxable to inheritance tax and not his Australian assets. But they had subsequently moved back to the UK, and because he had moved back to the UK, he was probably going to revert back for tax purposes to his domicile of origin, being the UK, which basically would have meant that his entire wealth anywhere in the world would have been subject to inheritance tax. So the reasoning or the advice that they seem to have received was that he would transfer his 80 million of investments into the wife's name because transfer between spouses is tax-free, and that she would then establish these trusts because she was Australian and she retained her domicile of origin in Australia and therefore wouldn't be subject to UK inheritance tax on her Australian assets. And because all of these assets transferred to her were in Australia, there would have been a massive tax saving. So that seems to be the intention that was put in place there. And the original court has then said, well, you put them into the wife's name, and the wife has therefore acquired these, and therefore they're shared as matrimonial property. But the Court of Appeal had a different outcome, is that right?
Yeah, the Court of Appeal took the view that the title being in her name didn't make the monies the wife's, that it was the intention behind it, and the intention behind it, as you say, for tax planning because of domicile, didn't make it matrimonial property, that the property was non-matrimonial property. But because it had been acquired by the husband prior to the marriage, now there was some of it where the husband had continued to work after they were married, and the court accepted that maybe 25% of the 80 million had accrued during the marriage, and that would be subject to the sharing principle. But the rest of it, the Court of Appeal took a completely different view, that the wife didn't have an entitlement to it. So they made the biggest reduction that's ever been made in any divorce award in England and Wales, and reduced her entitlement to 25 million, which was a reduction of 45%.
Which is obviously a massive change from the first decision. So it seemed to me that the first decision was what mattered was whose name was on the investment.
That's right.
The second decision was where did the source of the money actually come from? And then the Supreme Court seems to have taken the same view as the Court of Appeal, but from a different standpoint.
Exactly. They upheld the Court of Appeal decision where they didn't agree with all of the points that they made. But the most important thing that the Supreme Court said was that the sharing principle in matrimonial law shouldn't apply to non-matrimonial property. And they very clearly then set out what was matrimonial and non-matrimonial property. And they set out a new test saying that matrimonialisation occurs where there is was an intention by the contributor to share non-matrimonial property, coupled with the treatment by the parties of this property as shared over time. So I think as well it's relevant here that this was it was a relatively short time from 2017 that the money was transferred into the wife's name, and we don't know if it would be treated differently in another case, but it's still a very helpful test to have.
Yeah, because I think I saw that the investments were transferred in 2017 and the marriage broke down in 2020.
That's right.
And obviously we've had the whole appeal structure has taken place since then. But really we're only talking about 3 years that the wife held these assets, and it'd be interesting to have known, given the test that the Supreme Court saying now it's about the intention over time and how the treatment of these assets over time, would that have been different had the spouse held those investments for, say, 10, 15 years and still not established those trusts? Because maybe there's an argument there that the husband had acquiesced to her continuing to use these assets for her own means or for the means of the purposes of the marriage rather than for the children. So it's quite interesting that this was only over a 3-year period of time, and what would have happened had it been longer.
Exactly. I think that's a really good point, because the Supreme Court tried to set out 5 legal principles about making the distinction between matrimonial and non-matrimonial property. So they talked about looking at the source of the assets. Non-matrimonial property should not be subject to the sharing principle.
We'll maybe walk that back just a second, just so for the listeners. There's a couple of different principles that apply in terms of when you're dividing assets, isn't that right? There's needs, compensation, and then sharing.
Well, they're the 3 main. There are actually 5 overall, but the ones that are mostly looked at are needs, compensation and sharing. And I have to say, in large money cases, it's obviously sharing, because there's more than enough assets to see everyone in a very comfortable position. In the majority of cases, in day-to-day life, needs comes into it. What does each party need to rehouse themselves and any children? And the welfare of the children always has to come first. So while this is a really useful test, again, if there was a case where there wasn't enough money to apply the sharing principle to only matrimonial property, non-matrimonial property would have to come into it. So it's not going to be a fail-safe for everyone, that they don't have to worry about what they're bringing into a marriage or trying to protect it.
And the point about those different principles as well is that the Supreme Court's basically saying if it's non-matrimonial property, then the sharing principle just will not apply.
Exactly. And that's really helpful, because that hasn't been clear before. And different courts at different times have dealt with that in different ways, maybe giving the spouse a smaller percentage of non-matrimonial property. And that might still happen in cases where there is a needs element. But it's helpful to know, if you're dealing only with the sharing principle, that this decision is really saying you will not get any share of non-matrimonial property.
And a key point that I took from this as well, from a private client perspective as well, is that the Supreme Court has very clearly said that putting an asset into a spouse's name for the purposes of saving tax is not an activity that matrimonializes, that turns it from non-matrimonial property to matrimonial property, which is a very big point to take account of, because a lot of people do this. A lot of people will, for example, have one party of the marriage has higher income than the other, and they want to avail of the difference between their tax thresholds, and they maybe put then the property into the name of the spouse that has the lower income, so that they can get the full 20% rate rather than paying 40 or 45 on the extra. So that happens quite regularly, and this is very clearly saying that the act of doing that does not make it matrimonial property. It's really the intention of the parties, how they've chosen to deal with the asset for the marriage, and if they haven't, then it's not going to become matrimonial property in the sharing principle.
So from a private client point of view, that must be really helpful then when you're going to be advising people in the future.
Absolutely, it does make it a lot clearer from that point of view. That said, you're completely right. I mean, a lot of times needs and compensation are really going to be the key factors, unless you're dealing with those higher value divorces where there's a lot more money involved, or you're dealing with estate planning for people with a lot more money involved, and sharing principle could apply. And in those situations, then this judgment is going to be very, very helpful.
And you'd mentioned earlier, when we were talking about this case specifically, about domicile and how it affected the assets in this case. Is it relevant to private clients going forward to do the same thing, to look at domicile?
So not any longer. As of the autumn budget, domicile is no longer the determining factor in, certainly from an inheritance tax point of view, It used to be that it was always, either your domicile of origin, where you're from, or your domicile of choice, where you've decided to lay your roots down. That will be the determinative factor in terms of whether UK inheritance tax applies to your worldwide assets. That doesn't apply anymore. The new rules are that if you've been resident in the UK for 10 out of the last 20 tax years, then you will be charged inheritance tax on your worldwide assets. So domicile won't come into it moving forward. But in 2017, there's probably some pretty prudent advice that the husband transfer assets to the non-UK domiciled spouse so that they didn't fall within the UK inheritance tax net because the wife remained Australian.
That's good to know for people going forwards. They're not going to fall into the same trap as Mr. Standish and end up in a very expensive case.
Exactly.
I think because this the Supreme Court decision specifically deals with what's non-matrimonial and matrimonial property on a sharing basis, and as we say, most cases have to look at needs. There's definitely still a place for prenuptial and potentially postnuptial agreements for clients who have family businesses or any kind of assets coming into a marriage. So I think people still need that kind of certainty.
Absolutely. I mean, this case, what's really clear is that the sharing principle isn't going to apply and there's not going to be a matrimonialisation of assets if you can show that it wasn't the intention. An intention is going to come from evidence. You're going to need to evidence that some way. If you've entered into a prenuptial agreement before you've entered into the marriage and you've said specifically, this is how we're going to deal with our non-matrimonial property that we're bringing to the marriage, that's a clear evidence of your intention. And if you then subsequently marry and as life circumstances change and the finances change, you enter into further postnuptial agreements, again evidencing your intentions going forward, that's going to be really useful for trying to show what the intention was when it comes to the sharing principle. If you don't have any of those evidence, in this case, you had a file that showed what the tax advice was and what the intention was to transfer the assets to the wife and then into a trust. If you didn't have that, there was no evidence of it, the point might still be made, but you're going to struggle to prove it.
Because that's one person's word against another then, isn't it? If somebody disputes that I wasn't aware that you were only transferring the money for inheritance tax, I thought you were giving it to me because we were a married couple. Which
is the argument the wife tried to make in this case. She tried to argue this was an outright gift to me, which the husband was saying, no, it wasn't. It was only for tax purposes. Luckily luckily for him anyway, he had the evidence to back that up. If he didn't have the evidence, I think probably a very different story.
Exactly. But again, if he had done a postnuptial agreement when they were making those arrangements, he would have had even further evidence and it might not have got as far in the court as it did.
Precisely. It would not only show his intention, but it would have showed her acquiescence to that and shown that she agreed with it. Okay, well, that was really interesting, Kelly. Thanks for going through all of that with me. Obviously, any listeners that if you find yourself affected by any of the issues discussed in this podcast, you've Kelly Shaw at MKB to contact for any matrimonial concerns and myself for any private client concerns. So thanks very much for listening.
Thank you.